Hello, everyone. My name's Tim. You're watching Lost in Law. Today, we're talking about contracts. Contracts have a very special place in our legal system. They are promises that are binding and legally enforceable by our courts. Not every promise you make is a contract. And in fact, we're going to have a quick look at a case here that establishes exactly that principle. This is called Balfour v. Balfour. It's a case from the English Court of Appeal in 1919. Now, the facts are pretty straightforward. Getting a copy of this case was not easy, so I'm on Wikipedia right now because it's not on any of my Canadian sources. It would appear in a law book, but for copyright purposes, I certainly don't want to be showing pages of books on here. Now, anyways, just, take it with a grain of salt. And of course, the commentary is dubious at best. Do your own research. Oh, by the way, this is probably a good time to mention I am not a lawyer. This is not legal advice. Contact a lawyer in your jurisdiction for legal advice. Always got to make sure I do my little disclaimer, but yeah. So, anyways, as I said, Mr. Balfour is a civil engineer working in what is now Sri Lanka. Mrs. Balfour is living with him. In 1915, they returned to England, but Mrs. Balfour is required to remain in England on doctor's advice due to a sickness that she develops. Now, Mr. Balfour goes back to his job, and he promises her that he's going to give her £30 a month until she returns home. However, their relationship sours, and they separate. In 1918, Mrs. Balfour sued him to keep up with the monthly £30 payments, as she never returned to his. She never returned. So we have a promise, right? Until you return home, I will pay you £30 a month. Now, the question is, was that a legally enforceable contract? A trial judge agreed that it was, and that Mr. Balfour was under obligation to support his wife. However, the Court of Appeals finds that there is no enforceable agreement. There is, you can have a quick read of that passage there, but essentially what is being said is that if we were to hold all domestic promises under the terms of legal contracts, our courts would get so clogged with absurdity. So, the important thing here to realize is that not every promise you make in the domestic context is a contract. I'll give you a good example. If you have kids, you have been in this situation before. Hey, behave yourselves and we'll go out tomorrow. I have work to do. The house needs to be cleaned. I need to finish painting this fence, whatever. Stop doing whatever you're doing now. And as a reward, I can take you out somewhere tomorrow. Go for pizza, go to the park, whatever. And the next morning you wake up and you have a splitting headache, you're sick, whatever. You're not able to meet the obligation of that promise. And so, of course, the kids whine, but you promised. So you can cite Balfour v. Balfour in your defense and say, not every promise is a legally enforceable obligation. In fact, many promises you make in the domestic into the domestic context are not contracts. So, with that out of the way, what is a contract? A contract consists of the following parts: an offer, an acceptance, clear terms, a consideration, and the intent to create a legal relation. I did not have intentions to create legal relations with that woman. Whatever. Um, the case we're going to be looking at here, v. Perry, 1953, at the Supreme Court of Canada, is kind of going to help us determine what is a contract, especially when one is in place. Is there a contract in place? So let me first define some of the terms that I mentioned make up the components of a contract. So first is our offer, which is a pretty simple term to define. It's how you would understand it, right? There is something on the table, some sort of conduct I'm asking for from someone, a conduct or service or money, right? Something I am asking from someone else is the offer. The acceptance is that person's response in the positive. I accept the terms of your offer. Now, acceptance doesn't always have to be written. It also doesn't always have to be spoken. For example, when you walk into a barber shop and you tell the barber, I want a certain style done, and the barber looks and says, yeah, I'll get that done for $40. And so you sit in the chair and expect the barber to go to work. You have not said, I accept your offer to cut my hair for $40. But by conduct, you have been implied to have accepted that price. So when you get out of the chair and the barber finishes cutting your hair, you get out of the chair, you can't turn around and say, well, I didn't accept to pay $40. I'm only going to pay 20. Now, the other question is, would it be worth the barber's time to take you to court to get $20? Or is it more effective to ban you from their place of business and just take the loss on the $20? That's a question best answered by your lawyer. Remember, I'm not a lawyer. So, acceptance doesn't always have to be explicit. You accept contracts uh, by signing a piece of paper. You sign the terms of the contract. Rental lease agreements would be a good example of that. Employment contracts would be a good example of that, where you actually physically sign the piece of paper. That would be a written acceptance. That acceptance is seen as much more stronger than, say, an acceptance of, oh yeah, I agree to these terms, or even the less formal, sure, let's get it done. But those are still considered acceptance. So if you're forming contracts on a verbal basis, it always helps to have a witness, right? Someone who can say, yes, this person agreed to the terms of the contract verbally. Now, acceptance is often implied when you go and start doing your work, your side of the contract. But there are situations, and we might come across a few cases where that's not the case. So if you're thinking in terms of protecting yourself, you usually want some sort of proof, evidence, or a witness that the acceptance of the contract has occurred. Because from that moment forward is when the contract binds you. Never before it. No contract is binding before it is accepted. Now, we go to the clarity of the terms. That also known as certainty of terms in legal context, but this one's a really easy one to explain. You can't make a promise for something that is not quantifiable or has no way of determining how to quantify it. You can't make promises for you can't make a promise for some broad and vague term. You can't write down a thing that says, I'll do the work, right? With no other context, nothing else that defines what work is. You can't just say, I'm going to do the work, pay me this much. Everyone's going to kind of look around and be like, what work? What are we bargaining for here? This, I don't understand. So there also needs to be a certainty in the length of time that something is expected. So that's why contracts often have deadlines, expiration dates, or a certain term length, not to exceed however many months or years. This is done because without the certainty of when you're supposed to complete your side of the obligation, how could you be expected to uphold your side? Now, other things might be uncertain in the moment, and the contract specifies that when that term becomes certain, the contract is valid. A good example would be um, buying oil, which is speculative. You're buying oil in the future for future delivery. So, although the future price of oil is not certain, you can certainly create a contract that says fair market value, fair market price, or some sort of mathematical formula that would make the cost predictable, such as costs plus 10% or shipping expenses plus $5. So when the terms cannot be made certain, when it's impossible to make the terms certain, the contract needs to be able to tell you the conditions or the scenario in which those terms are made certain. And that becomes a binding contract. Consideration is what you return for the offer. So that can be money, and it often is money, but it could also be service for service. Um, a consideration has to have objective value in the eyes of the court. So your children's good behavior has no value in front of the court. And I know parents are chuckling to themselves, you've never seen my kids misbehave. Still, the objective standard is that there must be value. And the court does hesitate to determine what is the appropriate value for something. So you could sell, someone could do a contract to sell a McLaren F1 for $1. The person who made that contract, the seller, cannot go back to the court and say, "Well, this was clearly not worth. It was worth way more than that. Can you help me out here?" The court will say, "No, you signed the contract. It was worth $1 to you at the time. Therefore, it was $1." Now, when you get to the intention to create legal relations, that is what saves you if you make a very sarcastic remark and say, "Oh, whatever, I'll sell you that for $1." Right? Without the intent to create legal relations, there is no contract. None exists. There's nothing to enforce, there's nothing to bind. So, that also is a catch-all for a lot of the domestic promises people make, right? You promise your girlfriend something, you promise your spouse, your kids something, but you had no intention to create the legally binding obligation. So there's no contract there. There's nothing for the court to enforce. Your kids can't sue you for, breaking your promise. So again, not all promises are contracts, but contracts have a pretty specific structure to them. And as you'll learn, that structure then, you tear that apart with exceptions and rules. But we're not going to go too deep into that. We're going to quickly have a look at this case here, the um, the Harvey v. Perry case. Now, this is in regards to oil leases. And surprise, surprise, a dispute about oil leases is in Alberta. Surprise, surprise. Anyways, the gist of the facts here is that there was a lot of communication back and forth um, for the plaintiff in this case, Harvey, to purchase oil leases off of Perry. And there was right, this is what's up for sale, right? 8.5 sections between Wetaskiwin and Montrose, which I'll take $20 an acre for same, or will sell half undivided interest in this piece, and I will pay half of drilling well. Okay. Oh, you got to remember, this case is in 1913, so there's no internet, right? This was an advertisement that was placed. Yeah, it was a postscript in a letter. Yes. So, anyways, there's a lot of back and forth, right? And they're coming up with the terms, but they never actually agree on the terms of the contract. So when the defendant actually sells the leases to someone else, the plaintiff sues and says, "Hey, we had a contract. You were going to sell those to me." Now this goes to the Supreme Court. I do believe at the trial, yes, the trial held that the plaintiff had prevailed, and that the defendant was to owe the plaintiff. I don't know what the judgment was for, but in any case, the Supreme Court overturned it on appeal. So that's referred to by this term, appeal allowed. At the very end of the day, this is what the Supreme Court decided. The correspondence and the conversations, when considered as a whole, do not establish a contract between the parties. The appeal should, therefore, be allowed and the action dismissed. On his counterclaim, the appellant is entitled to an order directing the respondent to forthwith deliver up to him copies of the leases herein question and referred to in the statement of claim, directing the Register of the North Alberta Land Registration District to discharge the caveats filed by respondent against the titles to the lands here in question. Okay, there's a lot going on there, and I'm not going to get into all of that. Feel free to look up this case on your own if you want to learn more. The original book version of the case will be found in a Dominion Law Review. Dominion Law Review or Record? Yeah, review. Yeah, Dominion Law Review. So the 1953 edition, page 465. Oh, second. Sorry, that number 2 I think stands for second. What does that stand for? I actually forget a little bit what that number 2 means. I think it's the second book of the 1953 series, and then that is page 465. You can also find it here on Canley, so you can just type in Harvey V. Perry 1953, and it'll come up here on Canley. If you want to do your own research and learn a little bit more about the background. But this is the important part. The correspondence and the conversations, when considered as a whole, do not establish a contract, because a contract requires an offer, an acceptance, clarity of terms, consideration, and the intent to create legal relations. In this case, what happened was that the offer and the acceptance were not proper. Because these two parties were communicating back and forth and trying to change the terms of the agreement with each communication, they are still negotiating. There's so every offer that is rejected and then counter offered. So in the legal in law, when you reject an offer and then counter offer, when you counter offer, it is assumed that you have rejected the first offer. So this comes up a lot, right? Can you come down a little bit on your price? Someone selling a truck says 5,000 cash, right? So you go and say, would you take 4,000 in cash? Actually, that's probably a bad example because that's an invitation to treat. We'll talk about that later. But yes, in any case, someone offers you, hey, I'll sell you this truck, 5,000 cash. It's all yours. Where it as is, where is. So, and then you say, well, it's a lot of money. Could you do 4,000? Okay, at that moment, you have rejected the $5,000 offer and you've made a counter offer for 4,000. So now it goes back to the other person who owns the truck. Okay, will I do 4,000? No. 4,750. All right, so the seller of the truck has now rejected the $4,000 offer and countered with their own 4,750 offer. The the person then says, "You know what? Too much money. I'm walking away." And then the seller says, "Hang on a second. Hang on a second. What about 4,000? Okay, I'll do $4,000. I really need the money. I need this truck gone. I'll do the $4,000." And the guy says, "I'm not interested anymore. You're trying to take advantage of me." The seller of the truck can't say, "Well, hey, you agreed to $4,000. You're now bound by that." No, that was never, you know, in counter offering, you have rejected the offer that you're countering to. So you can't come back and say, "Well, you made that offer before, so now you have to stand by it." It's one of those things that makes sense in your mind as you think about it, but in terms of the law, getting it on paper, it actually is a complicated thing to talk about. But yes, when you counteroffer someone, they're under no obligation to go back to that first offer if they then decide, "You know what? You're not giving me a good deal here. You're trying to take advantage of my situation, and I really don't I I don't want to deal with you anymore." So, anyways, that's a short little video about contracts. You got to remember, contract law is an entire profession in and of itself. There are lawyers who spend their entire lives reading, establishing, and enforcing contracts. So you'll never learn as much as someone who's got 40 years of experience litigating contract law in just this short video from a first year law student. But perhaps there's some things about contracts you didn't know that you learned here today, especially if you're a small business owner. And it's important to know that ignorance of the law is never an excuse. So when you screw up, you think you had a contract or you think you didn't have a contract and the opposite is true, you're on the hook. You can't say, "Well, Your Honor, I'm not a lawyer. How was I supposed to know this was a contract?" So I hope you found this video interesting. Like it, subscribe if you want to see more. We'll see you next time.